Hi, I'm Derek McDaniel. I'm Mr. Eldercare 101. Thank you so much for joining our Webinar Wednesdays weekly webinar series. For folks who have not attended our webinars before, this is essentially how we run them. Number one, we try to have, let's call it 40, 45, maybe even 50 minutes of content. We want to give people a really good understanding, and we want people to walk away with actionable information. Because eldercare is a very, very broad field, and it is also in many cases state-specific, especially with things like legal documents here. You may not have the exact answers to every question that's applicable to you, but what we do want you to know is what options are out there so that you can go to your specific state representative or the lawyers that are in your state and ask them really specific questions so that you can get the best information possible, because that information will very definitely impact both the caregiver and the care recipient in numerous ways, just some of which could be financially, or more importantly, to my mind, the quality of care your aging loved one gets. All right, so with that, that's housekeeping stuff. Let's get into the content here. Listen, I'll put this slide up here because Rosalind Carter said it better than I've ever heard anyone saying it. There are four kinds of people in this world: those who have been caregivers, those who currently are caregivers, those who will be caregivers, and those who will need caregivers. Couldn't have said it better. And why that's applicable here is because the legal documents that you put in place will dictate so much of how the care is provided, the care that's available, the financial aspects, medical decisions, end-of-life decisions. So many different things are impacted, and therefore so many different people are impacted. You want to have these documents in place. You want to make sure that the documents are kept updated. You want to make sure that people know where they are. I mean, there's so many different things. Here, let's be a little bit more specific. For eldercare documents, or any sort of legal documents really, but most especially for eldercare documents, you want to make sure that things like wills, medical proxies, and we'll get into more of this stuff in the webinar, but you want to make sure that they're updated. You want to make sure that people know where they are. You want to make sure that you have multiple copies of them. For example, God forbid you have a will and the only copy of the will is in a house and there's a fire or something and the will is destroyed and the person is incapacitated. All of the things they've set up for themselves would be gone. So for things like that, just by way of example, number one, most eldercare attorneys will keep a copy of the document in their office. So ask them to do that. If you're using something like a LegalZoom, then you want to make sure that you have people, or you want to have multiple copies out there in the cloud or on a server in a different location or something like that. You also want to make sure that multiple people have copies, because as people age, they forget things. It's just a normal part of aging, even if they don't have a cognitive impairment. So you want to make sure that multiple people have copies. And if you do have multiple people that have copies, you want to make sure that when you update something, that people have the latest update of the document. Also, here's another option. A lot of county clerk's offices or other government entities, and I don't want to be too specific because this is a national broadcast, and different places may be called different things in different places, especially in different states around the country. So, but like a government or a county clerk's office may hold a will for people. It's a different place to file a will, just so, God forbid, something happens, the person's family can get a copy of the will. So investigate places like that as well. So, but we don't want to get too much into this. Let's stay on track because there's a lot of information to cover tonight. And I want to make sure that everyone gets the best information available. So, and in its most comprehensive fashion as possible. So now, the first part of any document or any legal document is going to be capacity. What does capacity mean? Well, basically, the long and the short of it is this. The person needs to have the requisite mental ability to understand the document and understand what they are signing and understand what the document means. Okay? Now, capacity, once again, this is one of those sort of things that different states interpret it slightly differently, but basically the person needs to understand at the time the document is being created on their behalf, usually, and most specifically at the time they are signing the document, what that document means. Okay, if they can't understand what that document means, then the document is most likely going to be ruled invalid. And this is one of the most common ways to challenge a will. For example, if a person signs a will and they're leaving $200 million to their cat, but they have 3 children and they have close relationships with those 3 children, and those children have always been there for them, someone's probably going to say at the time that person signed that document, they did not have the requisite mental capacity to do it at that moment. And by the way, capacity can be fluid. A person can have capacity early in the morning, but late in the day, they no longer have capacity. In that case, we're probably talking about something like people's sundown. There are capacity could be fluid, and depending upon which state you're in, will also determine who has to determine whether the person has capacity at the moment they're signing the document. Most often, it's the attorney who also usually has to co-sign the document, but we'll go on. Now, in terms of, and I'm sorry, I hit that button a little too hard. The very first document that we're going to talk about is a will. Wills it's essentially your ability to write down who you want to leave your possessions to. That's essentially what a will is. A will does not take effect until after a person passes away. There are other ways for them to protect their assets while they're still alive. Sometimes that might be a power of attorney, or in case of like medical directives, it might be a healthcare proxy, whatever. But please understand, a will does not come into actuality or does not become real until after a person passes away. That is the first and most important part of a will. The person who makes the will is usually called the testator, all right? To make a will valid, a person must possess the mental/legal capacity, we just talked about that, to know what he or she is doing. That's number one. Number two, the person must have a level of awareness to understand the essential elements in the will. This is more of a capacity test. Can they understand the names of the people that they're leaving things to? Can they understand what date it is? Do they understand the places or the items of importance? Essentially, do they understand that they're leaving their house to their cat, Fluffy? And I'm saying that in kind of a lighthearted way because this stuff can be really, really intense and very, very stressful. So I try and have a little bit of fun with it so that people can not stress too much and people relate to it a little bit. But please understand, these are serious topics. Hopefully the lighthearted example, though, will help people understand what we're talking about. And as I said, the person's mental state must be verifiable. Usually that is done by having a witness there or the attorney drafting the document also having to sign it, or a witness having to sign it, or a person having to notarize it. Those are sort of checks and balances to make sure that the person has the mental capacity when they create the will. Let's go on. We want to plan ahead. Executing advanced directives allows a person to maintain control of decision-making. It's best and most effective. It's the best and most effective way to express your desires and influence decisions relevant to you. Listen, what that really means is this. When you put together a legal document, you have control of what you want done, how you want it done, what is most important to you. If you do not do this, the risk is that someone else will decide how your assets are allocated, or what medical decisions will be made for you, or what will be done in terms of end-of-life decision making. You want to make those decisions for yourself if you have the desire to. And I think most people do, from my experience. So that's what we're really talking about here. And this amazes me, but when last checked, almost 70% of people do not have wills, or at least they think they do not have wills. Everyone has a will. Let me explain what I mean by that. If you do not create a will for yourself, every state in the United States of America has an ordered procedure of how to distribute your assets amongst your family. Okay, every single one. So if you don't create a will telling the state how you want your assets allocated to people you leave behind, then they will go along the checklist that they have, and that's how they'll do it. So in effect, everyone has a will. You just may not have the will that you want. Also, in terms of medical directives, if God forbid, you are incapacitated, you really may not want, for whatever reason, your feeble-minded third cousin to be the person who is designated as your medical decision maker. In that case, you may want to appoint the person who's been your best friend for the last 50 years, who actually knows what you want and has an idea, versus a court stepping in and going, well, he's only got one third mind or one third cousin. That was a little slow, but he showed up to court and he says that he'll do it. We're going to designate him. You want to make these decisions yourself. The only way you can really do it is by planning ahead. Next, move on. Oh, okay, right here. I put my contact information in here. As I said, at the end of every webinar, we try and have Q&A so that people can ask questions. Sometimes, though, we can't get to all of the questions, so please feel free to write me an email. I know, direct dial telephone numbers in there. That is the worst way to try and get in touch with me, because I travel a lot doing live presentations and stuff. Shoot me an email. I do get back to people. Sometimes it takes a little longer than I would like, but I do get back to folks. Also, if I tend to get, or if I seem to get a lot of the same questions, instead of writing 40 emails with the same answer, what I'll probably do is just put it on the Mr. Eldercare 101 website. So feel free to go there and check it out and look for responses to your questions, and you'll probably find some responses to questions that you either didn't get a chance to ask or didn't know to ask, or whatever. Great resource. Okay, with that, let's keep it going, because I see I'm a little behind schedule, and I also see the questions queue filling up, which is good, because that means people are really interested and they really want this knowledge. So